The U.S. Supreme Court heard more than an hour of arguments today concerning Alabama's congressional map and whether it violates the Voting Rights Act. That map was passed by the Alabama legislature last fall.
Now, the state has 7 congressional districts. 6 are majority white voter districts and 1 majority black voter district. The challenging groups persuaded a 3-judge panel that the map should be redrawn, but Alabama appealed to the Supreme Court, setting the stage for today's arguments. News 19 Chief Investigative Reporter Brian Lawson joining us now in the studio with more. Brian, what is in this dispute?
Right, this is really a technically complicated case from a legal standpoint. The issue is over the Section 2 of the Voting Rights Act, which says in part it is a violation of the act if it is shown political processes for nominating or electing candidates is not equally open, and that based on race or class, voters have less ability to elect candidates of their choice. Alabama says its map is race neutral and says remedies have to be as well. The plaintiffs say the map discriminates. Now, lawyers for the state of Alabama say the state's congressional map respects traditional districts, communities of interest, and doesn't discriminate. The district court previously found that given Alabama's growing black population, a second black majority district should be drawn, or one close to it. The high court focused both on the mechanics of how the map could be drawn and whether race neutrality had anything to do with the Voting Rights Act.
Essentially, what plaintiffs have to show as a part of their Voting Rights Act claim is that it's possible to draw an additional majority-minority district, and we did. We drew a district that looks very similar to a map that Alabama passed for its Board of Education at the exact same time that they passed this discriminatory map for Congress.
The Voting Rights Act, which was designed to take discrimination out of voting, cannot be used to affirmatively require the state to discriminate in how it draws its lines. We think that's essentially what the plaintiffs are pushing for here. But to the extent Section 2 applies to districting, it's to prohibit racial gerrymanders, not to require states to draw them.
Some of the justices pushed the state of Alabama on the purpose of the Voting Rights Act and potential remedies for discrimination. Justice Ketanji Brown Jackson asked, quote, "It's a race-conscious effort, as you have indicated. I'm trying to understand why that violates the 14th Amendment, given the history and background of the 14th Amendment." Solicitor General Edmund McClure replied, "The 14th Amendment is a prohibition on discriminatory state action. It is not an obligation to engage in affirmative discrimination in favor of some groups vis-a-vis others." Now, the plaintiffs told the High Court Alabama's black voters are 27% of the population, but control just 15% of congressional districts, while white voters are 63% of the Alabama population, but control 85% of congressional districts. The court's ruling is not expected to be issued until late spring of 2023. Jerry?